Good. Well, I'd like to get started now, and I'd like to welcome everybody to ICSID and to the event tonight. We are very lucky to preview this new book, which is the International Arbitration Rulebook, and it's very interesting because it does a comparative analysis of 9 of the world's leading sets of arbitral rules through arbitral institutions. And it's really a fascinating read to just see how different institutions deal with things and whether they deal with them differently or the same. And I can say certainly for us at ICSID, it's been especially interesting because we've been in the process of a very large rule amendment. So this is very timely for us, as well as I think many people in the audience who are working in this field. I'd like to start by introducing the authors who are our panel today. So we have in order Arif Hyder Ali, and Arif, of course, is the co-chair of Deckert's International Arbitration Practice. He's been lead counsel in numerous cases, investor state as well as commercial, and representing both states and private parties. He's been at the International Court of Justice, at the U.S.-Iran Claims Tribunal, and the United Nations Compensation Commission. So he has very broad experience with different international adjudicatory bodies. He is a recipient of the Order of Bahrain and Law 360's MVP Award. And he is Pakistani by birth and passionate about the importance of multiculturalism in the practice of international arbitration. And I say that in particular because one of his co-authors, Jane Wessel, will be talking about some of the cultural differences and how they come through in the process. So Jane is a partner at Arnold & Porter. She has a practice that's focusing on antitrust litigation and international commercial and investor state arbitration. And she's got particular expertise dealing with competition damages litigation in the English High Court. But in terms of arbitration, she's got experience under all of the major sets of rules, both with commercial arbitration and also investor state under the ICSID and the UNCITRAL rules. So welcome, Jane. Beside Jane is Alex de Gramont, who is also a partner in Deckert's International Arbitration Group. He's been working on international arbitration and cross-border work for about 30 years and has been counsel at a number of ICSID cases going back to the early 2000s with Aguas del Tuneri in Bolivia, which set a number of new benchmarks in arbitration. He has also worked in arbitration cases in Africa, Asia, and Europe, and throughout the Americas, and also is a frequent lecturer and an adjunct professor of law at Georgetown University. So welcome. And finally, beside Alex is Ryan Mellske, who is the founder of Flex Arbitrate, and he focuses, of course, on the resolution of international commercial and investment disputes. He's done a number of major treaty and contract cases, including the famous Abaclat in Argentina, I think the largest number of claimants in any particular arbitration that we've seen, as well as a recent case, ConocoPhillips in Venezuela. And Ryan also is a senior lecturing fellow at Duke University School of Law. So thank you very much. We are delighted to have you here and have the opportunity to profile this book. In terms of the order of proceedings today, what we are going to do essentially is to have 4 short presentations, one by each of the speakers. And what we'd like to do after each of the presentations is to open up the floor for questions or comments or observations by you. So we're going to expect not just our speakers to work, but also our audience to be a part of this conversation. And if you are on the line, we'd like to have your thoughts as well. And basically, you can ask any questions if you send an email through the chat box on the lower right-hand side of your screen. You send that directly to Damon Vies Dunbar, and we will have your question and pose your question to our speakers. And finally, if you are on the web version of this, please make sure that you mute your microphone, and we're delighted to have you as well participating. So without any further introduction, why don't I turn it over to you?
Great. Well, Meg, thank you very much for that lovely introduction and for hosting us. Truly a real privilege to be here at the centre's new facilities, which I must say, from the ground up, look quite stunning. We're looking forward to having many hearings here and to ensuring that those who come to Washington, D.C. for dispute resolution are aware of these facilities so that you may be overrun with demand. But thank you again. This is very, very generous of you, and we're extremely proud to be doing this launch here at ICSID. I'd also like to thank Damon for all of his hard work and everyone else, the ICSID staff that's been so generous with their time in helping us to get this pulled together. Of course, my co-authors, about whom I will say something in a couple of minutes. And then I must say as well to my family, I have never permitted any member of my family, particularly my parents, from attending any event at which I have spoken, any of my trials or any of my arbitrations, for fear that my mother would start taking out pictures of when I was 2 years old and start showing them to everyone. But I did ask Meg in advance that I would be given certain extraordinary injunctive powers for these proceedings, not because any injunction that I might issue would restrain my mother in any way, but rather to enjoin all of you from eliciting from her or any of my other family members anything that might be embarrassing and would cause me to lose any sense of dignity that I might have left after this event. So, well, thank you all very much for coming, and I'm very proud that my son is here as well and very pleased. So I thought where I'd start is with what prompts rulemaking and changes to existing rules. I think that we don't often pause and think about why we have rules and what is it that we are intending to achieve by promulgating new rules. And of course, if you go back in time immemorial, from the Hobbesian state of man, or whether one and woman, or to the book of Genesis, we find that there have been rules and edicts that have been issued. And if you try and distill from philosophy, from law, from lawmaking, what the essence is, it is to impose order or hierarchy, or to memorialize the status quo. We develop rules to cater to our need in life and in commerce for predictability and order. Often to give effect to certain principles that might be reflected in contract, or that might be reflected in statute, or in the case of the ICSID Convention, in treaty. So we see in the ICSID rules in particular a reflection in the rules of what is in the treaty, which reflects certain policy imperatives and objectives that were intended by the member states when the treaty was first negotiated and continues to have a life. We also develop rules to create a framework for participation and to facilitate fairness. And I think that it's important to keep this in mind. What we're trying to do with rules such as the arbitral rules is to achieve a balance between the objective of efficiency and the principle or the right of due process. And the question that we each need to ask ourselves as we review rules and we consider what their effects are, what their intended effects are, is what is it that we are trying to protect? A right of due process, but at the same time promote efficiency. Efficiency is not a right. And so that is something that you'll see in all of the rule regimes that the arbitral institutions have tried to address in different ways, as we'll be exploring this panel. We also try in rulemaking to respond to lacuna that practical experience demonstrates need to be filled. And I think this is also very important. The difference between theoretical rulemaking or trying to address theoretical problems, trying to ensure that, and there are often rules that are redundant, that are not removed from during the course of the rulemaking process. But we need to make sure that the delta between the rules and reality is closed as much as possible. And I'll come back to that in a couple of moments. So it's with those sort of thoughts that have always, at least, impacted my thinking about rulemaking, that this book started to have some sort of, intellectual germination. And it really actually practically began, and someone will know this, with an assignment that I was given by a client many, many years ago to compare different rule regimes in order to recommend to that client which of the institutions that that client should focus on and start including in its various contracts. In fact, Jane and I and Alex and I have worked on several projects of that nature for clients, because clients do, or the users do, want to try and gain a more intimate understanding of various rule regimes. Well, before I knew it, there were 300 pages of text, of course, all of which the client didn't pay for, but nonetheless. And there were various tables of comparisons, and this whole thing started to get carried away. And then, as often happens in life, well-laid plans get waylaid, and the different institutions started to change their rules. And with each set of changes came further delays in being able to get this project off the ground. And I knew that I needed help desperately, and I needed help that was experienced, intellectual, but also compassionate and patient with me. And there came Jane to assist at the coalface, a practitioner with an immense amount of experience in international arbitration, with a lot of practical insight, but also with a theoretical underpinning of to give to her practice. And so she was an ideal person to join me. And we were colleagues at the time at Crowell & Mooring, a firm to which we owe a deep debt of gratitude for their continued support of this project. But then Jane and I soon felt that we were overwhelmed by what was a 300-page tome that is now 700 or some pages. And I impressed upon Jane that whenever I am in real trouble, I mean real trouble, the person that I turn to is my best friend and law school roommate and constant savior in hearings and in meetings, Alex de Gramont. And so Alex, who brings to the table immense amount of experience as a litigator, as an arbitration practitioner, as an arbitrator, came to our aid and joined the team, and the text began to grow and grow. We began to have great debates amongst Jane, myself, and Alex, and so we needed a mediator. And there came Ryan to the rescue with his superb organizational skills, with his academic insights, with his passion for international arbitration, and the person who I think carried the baton as the anchor runner to get things over the line. So really, a deep debt of gratitude to all of you. And for as long as this book remains on anybody's shelves, we will all be bound by this common endeavor of love and this albatross that is no longer around our necks. And so let me tell you a little bit about the structure of the book, because I think it's important to understand the way in which we decided to approach such a huge undertaking, because of course there are a massive number of rules that are out there. And we had to come up with some sort of organizational structure. You can read about why we selected particular rules in the preface, but we start out by trying to give you the essence of different arbitral institutions and how they are governed, how they select arbitrators, how they scrutinize awards, and as well as their case management philosophies. And every institution, I will impress this upon you, that every single institution has a very, very different case management philosophy. And every single institution also engages in case management in varying degrees of intensity as well as skill. And so it's important to try and get an understanding of what it is that these institutions, how they go about doing what it is they are offering as a service. And a service it is, and we shouldn't forget that. And this chapter in particular was based on a number of different surveys, phone calls, as well as academic literature and the literature that's put out by the institutions themselves. We then decided that we were going to focus on agreements to arbitrate, and we look at agreements to arbitrate, and this is in chapter 2, from the standpoint of identifying what it is that the rules actually say about a particular issue, such as place of arbitration or number of arbitrators, because certain rules will have a presumption for a sole arbitrator, other rules will have a presumption for 3 arbitrators, certain rules specify a default place of arbitration, other rules don't. And so we wanted a contract negotiator to be able to go to a single chapter and to look at what are mandatory provisions that must be included to have an effective and enforceable arbitration clause, and then parts of those are elements of an arbitration clause that are optional, but that are in fact very useful to include depending on the particular circumstances. And so as you go through the book, you'll see that we deal with commencement of arbitration, appointment of arbitrators, we deal with the conduct of hearings, we deal with damages, we deal with extraordinary new provisions and measures that arbitral institutions have promoted. And I think one of the most interesting chapters for me is chapter 6, which deals with evidence. As you'll see that in looking at that chapter, there are all of the different rule regimes take a very light touch to evidentiary issues. But what we did was we took every single provision that we could find that could remotely touch upon the regulation of the eliciting of and the presentation and evaluation of evidence, and we married that to the relevant provisions of the IBA rules on the taking of evidence. And so it's very interesting to see how the IBA rules match up to, supplement, or in some cases contradict what you might find in the various rule regimes. And so in each of the chapters or in each of the analyses that we go through, you'll see where it is that there's conflict and where there is where the rules might complement each other. And what it is that we hope that the book will achieve? We hope it will serve as a source for further advancement in intelligent rulemaking. We hope that it will facilitate amongst arbitrators a cross-comparison of procedural tools that they might be able to borrow from in ensuring that there is efficiency and due process appropriately balanced. We're hoping that this book will continue to serve as a great teaching tool for those of us who continue to be involved in academia. And ultimately, we hope that it will facilitate innovation, because I think that we need that. And there's one message that I have to all of my colleagues here on the phone at other arbitral institutions, is the importance of the institutions being bold, being confident, and understanding that they are far more important as the drivers of the global framework for international dispute resolution than they might perhaps appreciate. So with that, Meg, back to you. Thank you.
Wonderful, thank you. I'm going to take the prerogative of asking the first question. You talked about boldness and innovation. Are there any particular innovations of recent that stand out in your mind as important steps?
I mean, there are many, and I think some of those are reflected in rules, the rules that have been developed. I mean, we know there have been, I think, very successfully promulgated rules on expedited arbitration. I have recently become a fan of MedArb. Mm-hmm. I think that we continue to underappreciate the fact that we are not arbitrating for the sake of arbitrating, but our function as practitioners, as arbitrators, is to resolve a dispute. We resolve a problem rather than exacerbate a problem or contribute to a framework that won't allow the problem to be resolved efficiently. And so the other tools I've seen have been those that should be memorialized, mm-hmm. but no one has yet memorialized in their rules. For example, procedural facilitation. One of the things that we see that costs a lot of money and takes a lot of time is the procedural wrangling that takes place from the time a request for arbitration is filed until the first procedural hearing. And the first procedural hearing, in my experience as an arbitrator, I've found has often not resulted in a conclusive outcome that puts the arbitration or dispute resolution process on a good and efficient path. So what we've done, what I've done in the past is have appointed a young arbitrator as a procedural facilitator to work with the parties to try and reduce the number of issues that will actually come before the tribunal. And it is incredible to see how the parties will actually, with the help of somebody who has no dog in the fight, no skin in the game, but who will then come closer to addressing such issues as timetabling, addressing procedural issues, thereby resulting to a far more successful procedural conference. Now, this sort of shuttle diplomacy can be done well in advance of the first procedural hearing, or it can be done during the first procedural hearing. But what tends to happen is when parties are before arbitral tribunals, the posturing begins, the gamesmanship begins, the strategery begins, the aggressiveness gets in the way. And so the arbitrators are left having to try and come up with a solution for which they are at that point in the dispute resolution process ill-equipped to address. However, the parties, when they're dealing with somebody who is not going to be part of the arbitral process, are far more willing to disclose more about their case to the facilitator and thereby achieve recommendations that the parties are then willing to accept. And what I think the added benefit of this is that it allows for the next generations of arbitrators and facilitators and mediators to obtain great training as they step into the shoes of some of the giants that we all continue to rely upon.
It's an interesting idea. Does anyone have a question for Arif? All right, I'm going to ask you one more, and then we'll get Jane to talk about different cultural influences. You've been both counsel and arbitrator. Are there any particular frustrations that you've got that maybe the rules don't address? Sounds like yes.
Yes. But I think, again, I go back to the theme earlier on of trying to reduce the delta to something that is sensible between the theory of rulemaking and the practicality of what it is that we face as counsel and as arbitrators. Yeah, I think that where the institutions need to focus in the continuing education of arbitrators is to force arbitrators to more actively manage the dispute resolution process. As disputes have become more complicated, as law firm and counsel fees have become greater drivers of dispute resolution strategies, unfortunately, as the world of arbitration has also become a lot more complex across the globe with different participants. I think arbitrators need to take a more active hand in managing a dispute resolution process. And I find that that's something that's very frustrating, is to see arbitrators not being very well prepared, or being very well prepared but being very passive and saying, well, it's your arbitration, you figure it out. Well, no, we're disputing parties. There's not a whole lot that we've been able to figure out, and now you're asking us to try and figure out things that we are just incapable or ill-equipped to do. I think the other thing that I think it really is very damaging to the arbitral process is the length of time that it's taking for every institution, with all respect, Meg, ICSID as well, to appoint tribunals. Sometimes this is an opportunity for parties to settle, but unfortunately disputes have not been sufficiently cooked in order for the parties to be able to really slice into a good meaty settlement pie. And I think that that institutions, if there's one thing that they need to do, that I would prioritize, is to really push on this notion of getting a tribunal in place quickly. We have expedited rules and we have emergency arbitrators because of that gap between the time of a request for arbitration and the 6 months sometimes that it can take for a tribunal to be appointed. And the third thing I'll say is, as counsel, is what I call the black hole of deliberations. And I think that this is something that is amongst, probably up there for me in terms of damage to the arbitral system. It's up there with double hatting of arbitrators. But this is something from a user perspective that users have complained about time and time again, and the very real effect that the black hole of arbitral deliberations has on the realities of jobs and lives and investment and commerce and political discourse is that you leave the final hearing, and what happens? Arbitrators go off, they go on to the next arbitral hearing, and you hear nothing from them, sometimes for 2.5 years. And you have no idea what is going on. That is fundamentally wrong. It has got to be incumbent on every arbitrator to tell the parties on a constant basis through the Secretariat or however, any other means, that here is where we are. This is where you can expect your award, because that has a very real life effect on the various dynamics that I mentioned. I think as counsel or as arbitrator, I would exhort parties. I think parties need to get beyond their trepidation and need to help the tribunal to crystallize disputes early on. Mm-hmm. It's what do parties do? They come in, they vomit documents, and they vomit advocacy, and then they leave it up to the arbitrators to try and figure out how to deal with the dog's breakfast. And that's, again, something that arbitrators and counsel need to be doing in the service of their clients. I don't think as counsel it helps arbitrators at all, where you're faced with aggressiveness and everybody trying to be Perry Mason or rumbled at the Bailey. There are other ways of advocacy, and ultimately you're there to assist the tribunal in the representation of the interests of your client, not to showcase your own oral brilliance. And then the last thing I'd say is just the length of submissions. I don't think 600-page closing briefs or 600-page memorials help anybody, and I think counsel need to be penalized for making arguments that are superfluous and that ultimately don't assist the tribunal. So a few of my pet bugaboos.
Absolutely. Thank you. Jane.
Meg, thank you. So I'm not, thank you, Arif. There were some very interesting points you made there, which doubtless we will discuss later. I'm not going to talk about what is in this book. I instead want to raise an issue which has been prominent in my mind during the course of writing this book and working with my esteemed colleagues on that task, which has finally come to an end. Yay! And that's, the question is this: are we doing enough in the arbitration community to cater for the cultural differences that inevitably come to the table in any international dispute? So we boast as an international arbitration community that if you bring your disputes to us, we will give you a level playing field. We will eliminate the difficulties that one party might face if it were to litigate the dispute in the courts of another party. No level playing field. Are we really doing enough, though, to ensure there is a level playing field in international arbitration? I'm not sure we are. And so with that provocative thought, let me contribute these further thoughts. The problem is really this: everybody involved in international arbitration in any one case brings along to the table all the baggage of their own cultural background, legal education, business experiences, legal experiences. And all of that bundle of experiences and education will have taught that person what they think best represents fairness. How do we get a fair result with any particular dispute? How do we go about it? What are the processes that are due to give someone due process? Well, the difficulty is we'll have different answers to that question. So a couple of examples. Can you reach a fair result in any formal dispute resolution process without having discovery? Well, no, of course not. Say the Americans in the room and the Brits and all the others from, or most of the others from an Anglo-Saxon legal background, from a common law background. Well, of course you can reach a fair result without discovery, say the French and the Chinese and many others from a civil law background. And indeed, those people go on to say, it would be wrong for this process to impose on me all of the costs and trouble and expense of going through that ridiculous process, which is completely unnecessary to resolve this dispute. How do you square that circle? You've got two completely diametrically opposed views of the right way to go about it. Another example, cross-examination of fact witnesses and experts. Do we need it? Well, yes, of course we do, say the Anglo-Saxons. How on earth can you otherwise test the evidence of that particular witness and really get to the bottom of the documents in the case in the correct context? Of course you need to have the right to cross-examine them. Well, of course not, say the French and the Chinese and so on, for the reason that in their systems, the documents are where the answer lies, not in what witnesses appearing for the parties who may well have their own self-interest and their own spin. I'm not suggesting people would tell mistruths, but we all know that the same event looked at from different angles can look very different indeed. So again, we've got an example of a procedure which from one tradition looks like something that's essential to reach the right answer, and from the other looks like something which absolutely should not be included in order to reach the right answer. So as you look at that dichotomy, you wonder, how do you square this impossible circle? And do the arbitration rules, which we've covered in this book, do anything to help us resolve that difficulty? Well, let me just take a step back to some years ago when we were discussing, Arif and I, which rules to include in this book. And of course, we needed the most important and influential ones. So of course, for commercial arbitration, we had to have ICC, LCIA, the whole alphabet soup of rules. We discussed whether to include the ICSID rules, because those weren't commercial, and we decided that yes, we should, because it's a very important system of rules based on focus particularly on investor state, and it would be remiss of us to leave those out. And then we wondered what else. We decided SCC, the Stockholm rules, had to be in there because of their prominence with Eastern European former Soviet state disputes, particularly, and of course in more recent years more and more investor state. And we included the UNCITRAL rules, which, although not institutional, of course, serve as a proxy for many of the good regional rules that have popped up around the world and are in common usage. So we thought that would be, whilst not quite within the parameters of our plan, because not institutional, we thought that would be an important set of rules to consider. And then 3 sets of rules from Asia: CETAC, Hong Kong, and Singapore, which was actually a late entrant into the stakes, but that has become more and more prominent in recent years. But we've got nothing from the Middle East. We've included nothing from South America. We have nothing from the Indian subcontinent, and we have nothing from Africa. Now, Arif and I were discussing this earlier, and he's quite right. The UNCITRAL rules are, to some extent, and were always intended to act as a proxy for those regional rules. But are we really saying that there aren't any rules that really should be looked at more closely from those regions to see how they deal with some of the issues? There probably are, but frankly, 9 rules was enough for this particular exercise. I point this out merely to make perhaps the provocative statement that our own selection of those 9 sets of rules displays our own bias when we were deciding how to go about this book, because we selected those rules which we as European and North American practitioners saw as the most important and influential. And if we'd have been looking at this from somewhere else, perhaps we would have chosen different rules. So there's a bias already in the choice of the rules to be covered in this book. It seems to me that the important thing, if we are to level the playing field, is to think more clearly about the nationality of arbitrators, and going deeper than just their nationality, but looking at their experiences outside their own home state, which of course many have, because that is inevitably going to influence the kind of arbitration that those arbitrators are going to run. I had a look around for some statistics about nationality of arbitrators, and frankly there isn't that much out there to be found. I did find some statistics from the ICC from 2018. Those show that 65% of arbitrators appointed that year were from Western Europe and North America, whereas only 48% of parties were from those countries. I thought that was interesting, that there's a leaning towards Western Europe and North America for the arbitrators, even in that case. And then I looked at ICSID's stats. In the most recent report, that shows that in the whole period from 1966 to the 30th of June this year, we've only got the statistics for the respondent states, not for the claimants, only 12% of respondent states were from North America, including Mexico, I believe, and Western Europe. But 68% of arbitrator appointments were from those regions. And if you look at 2019 alone, the year to the 30th of June, same 12% of cases were against Western European and North American states, but 73% of the arbitrators were from those two regions. What's going on there? Is it ICSID's fault? Well, no, because then you look at the percentage of those arbitrators which were appointed by ICSID and those appointed by the parties. And in 2019, 83% of those Western European and North American arbitrator appointments were by the parties, not by ICSID. So something is going on there, and I don't know what it is, but there's a disparity between the parties in the arbitration and the arbitrators they choose to appoint. My theory, based on very little fact, is that there is a leaning towards the Western way of doing arbitration that makes the parties believe that a Western arbitrator is going to be better at doing it. And that implies that there's something wrong either with the rules or with the way they're being applied. Because the implication is that the Westerners will know how to play that game better than people from other regions around the world. This, I think, is worthy of further study, because I think it's an enormously interesting question that we could all benefit from looking at. If we were to find out why these appointments are happening, not that I'm trying to do us out of work, obviously, but if we could find out why those appointments are so biased, if I can use that term, towards the Western Europe and North American arbitrators, I think we might learn something about the way our rules are skewed. Now, don't get me wrong, in my own experience, arbitrators, even those from Western Europe and North America, work enormously hard to try and eliminate anything in their process that might favour one party over another. Some don't, most do. I think that's fair, don't you?
I can disagree.
All right. But I'm not sure that people are quite thinking about it in the right way, because they are not necessarily questioning their own biases and the assumptions that they bring to the hearing room. So thank you. That was the thought I wanted to plant in everybody's head.
Yeah, that's really interesting. Does anybody have questions or want to volunteer theories on why we appoint from certain regions and not others, or certain types of people and not others. So open to the audience. I know this is certainly something that we look at when we are trying to diversify the pool of arbitrators. And I'd venture a guess that one of the problems is that nobody wants to be the first to test a new arbitrator, so they keep going back to what they think are known commodities. But of course, it's got to replenish itself, so it's hard to get that balance. But it's a good point, worthy of study, as you say. Do you find there were cultural differences that went to whether an arbitrator felt comfortable to play that role of arbitrator-mediator and to take off a strict arbitrator hat and try to get more into what Arif has said is problem-solving?
Yeah, of course, some international arbitration rules specifically allow an arbitrator to act in the role of a mediator. That's in the CTAC rules, and it's also, I believe, in the Japanese Arbitration Act, as well as in the Japanese arbitration rules. And so somebody can act as a mediator, and then they can take that mediator hat off, put on an arbitrator hat, sit and arbitrate, perhaps halfway through the arbitration, take the arbitrator hat off again, put a mediator hat back on again. And to us, from the common law tradition, that raises all sorts of difficulties. We wonder, for example, how a settlement offer that's made when person A, shall we say, has the mediator hat on, how is he going to eliminate that from his mind when he's put his arbitrator hat back on? On the other hand, perhaps a mediation can't work as effectively because the parties will be reluctant to share confidential settlement offers or discussions with that person when they've got the mediator hat on, because they know the person would still be thinking about it when they're an arbitrator. I think there might be enforcement problems too in some countries, because if you did have somebody who acted in that MEDARB kind of role for the substance of the arbitration as opposed to the procedural role which Arif described, it does occur to me that there might be a lack of due process New York Convention challenge available. Of course, there'd be consent to argue on the other side, but in the Western countries, I think there may be some kind of enforcement problems, or at least there'd be room for a challenge.
Interesting.
So I don't know how to square that circle either. I think the idea of using somebody separately to mediate procedural issues during the course of the arbitration is an excellent notion that could help to short-circuit a lot of the rubbish that tribunals have to take up their valuable time with. But for the substance, I think it's more difficult.
Perhaps I could offer a thought on MEDARB. I think that the issue of culture in arbitration, I mean, it's a very complicated one, and I mean, leaving aside, perhaps ICSID is the right place, the right institution to facilitate a discussion that is truly raw about this, and that's what's needed, because I think we, in public fora, tend to be nuanced about calling it what it is. I think that we don't tend to focus on the historical, cultural, colonial biases that exist both ways. That it's not just the oppressor and the oppressed, but it's rather, so it is a complex problem, and I think it warrants discussion. But specifically on MEDARB, I think in the northern countries, or the developed economies, or those that say what you were referring maybe called Western countries, the style of mediation is focused a lot more on caucusing, whereas in Asia, in parts of sub-Saharan Africa where mediation actually has taken place, and in the Middle East where mediation actually is what you might call majlis mediation, where in the majlises of the prominent industrial houses or prominent families, people are resolving disputes. There is an emphasis on openness. It's extremely important that you don't go into a room and caucus, because there are issues of bribery, there are issues of undue influence, there are issues of, you're having a secret conversation. So the sorts of mediations that take place in the traditions where you find that MEDARB is reflected in the regulatory regime, such as in the CTAC rules or in the Japanese Arbitration Act, is because the mediations there are actually more like conciliation, non-binding arbitration, where everything is far more open and is completely open. So I think there's that particular difference in terms of model, and the Western model of mediation as we know it would not necessarily work within the CTAC context. I think the other aspect of MED-ARB is where particular claims, and you see this in construction arbitration all the time, is that particular sets of claims that are simple, and they could be even high value, are taken and put on a different track for purposes of resolving those claims. And I think that that's something that doesn't then make it difficult for the chairperson of the tribunal to then continue to sit as an arbitrator. Yeah. But it's, I mean, construction arbitration or dispute resolution is I think probably amongst the most creative procedurally of any of the systems out there.
Yeah, it's interesting. It's true. Let's pass to Alex, who's going to talk a little bit about how you identify the differences between commercial and investment arbitration and what the implications are for a counsel and for an arbitrator.
Thank you, Meg, and thanks to ICSID for having us. Thanks to all of you for being here this evening. When I was preparing for this book launch here at ICSID, which is, as everyone knows, the premier center for the resolution of investor-state arbitration, I came up with what I thought would be a fantastic topic, in part because I knew it was going to be so easy for me to present it. And as it turns out, it was not so easy to present it. The question is, are there particular rules or particular regimes that are especially well suited to investor-state arbitration versus commercial arbitration? And again, as I poured through the rules, I found that the question was much harder than I thought it would be. And it may be that the role of the rules, as opposed to the role of the parties and arbitrators, are very different and may help to answer some of the questions that we've been discussing. So let's start with a proposition on which I think we can all agree, at least at the general level, right? Which is that investor-state arbitration is fundamentally different from international commercial arbitration. It seems obvious, right? Commercial arbitration involves private individuals and private entities. The effects of the award generally won't go beyond the individuals or the companies that are before the tribunal. By contrast, investor-state arbitration can affect the lives of every person in the state before the tribunal. It can affect millions of people, tens of millions of people, hundreds of millions of people, depending on the state in question. Think of the potential impact on the state treasury. Think of the ability of the state to regulate, which we hear so much about in this context. Think about TechMed and the landfill cases, the various mining cases where we hear about pollution and threats to the environment, threats to water sources, etc. Think about the tobacco cases. There is a reason that investor-state cases have gotten so much attention and have generated so much controversy, regardless of their actual outcomes and regardless of how they have actually been handled. It's the possibility of what a large investor-state award can mean for the millions of people of a state. I mean, it's very easy to imagine. It's very palpable. It's why I suspect that when we have represented, and we have occasionally represented investors in high-profile investor-state cases. We have had people protesting outside our offices. We have had people protesting outside the World Bank. Strangely enough, when we have done contract cases between private entities, no one seems to be terribly interested. So to me, it's obvious that the regimes for investor-state arbitration, how we handle investor-state arbitration, should be different than how we handle commercial arbitration in at least three respects. The first is transparency. Given the potential public impact of the proceedings, the public has a right to know what is happening. The proceedings should be open to the public so that the public can see how controversies that affect them are being handled. And opening the proceedings, I think, will let the public know that for the most part, the tribunals conduct these cases with exceptional integrity and exceptional care and exceptional attention. The second is the role of precedent. We all know that in international arbitration, there is no such thing as binding precedent. That's very jarring for many of us who were educated in the common law system where stare decisis is such an important principle. In the context of investor-state arbitration, I believe that given the public importance of the awards, there needs to be a significant degree of consistency and predictability, that there should, in fact, be jurisprudence constante, a constant jurisprudence that people know and can rely upon, and recognizing that facts vary from one case to another, still have some predictability on what the outcome is. And the third is having arbitrators who really know public international law and who really know the jurisprudence of investor-state arbitration, which is having started off doing commercial arbitration. I know that the jurisprudence of investor-state arbitration is quite different, and it takes a long time to learn and master. So I think that all of those propositions that I've just stated are not terribly controversial. I'll be interested to know if people disagree, and hopefully if you do disagree, you'll speak up. The harder question is whether we can and whether we should draft rules that address those differences, those three critical distinctions that I just mentioned. And I think on the question of transparency, the answer is yes. For example, the proposed ICSID rules, if they are implemented, will require the award to be published if there's no written objection within 60 days of the dispatch of the award. And even if there is an objection, the award, as well as the orders and decisions of the panel, will be published, albeit with redactions, as agreed upon by the parties, and if the parties can't agree, then as ordered by the tribunal. A number of treaties, CAFTA, for example, provide that all of the proceedings are open to the public. All of the submissions are publicly posted. The hearings are open to the public. I recall that Arif and I and Meg handled the PACRIM versus El Salvador case, which I believe was the first case that was broadcast over the internet. And I generally don't allow my family to come to proceedings either, but they watched it on the computer. In fact, my 5-year-old was very upset because it was translated into Spanish, And my 5-year-old was very upset when he saw me on the TV screen, and my wife had switched it to the Spanish channel, and instead of my voice coming out, the woman's interpreter's voice was coming out in Spanish, and he was quite disturbed by that. And then there are other instruments, the UNCITRAL transparency rules, the Mauritius Convention, that should take us more in the direction of greater transparency in investor-state arbitration, and I think that is really critical. On the other hand, if we take the question of precedent, of consistency and predictability, I have tried, but I cannot envision any set of rules that could address that. A number of investor-state tribunals have explicitly recognized and identified the need for consistency and predictability without always delivering them. But I candidly think that that's the best we will be able to do on that. I don't think that the rules are the place to prescribe a sort of stare decisis for use in investor-state arbitration. And on the question of qualified arbitrators, I also think that that's probably not a question that can be addressed by rule changes. And even if we tried, I think we would run into some of the dangers that Jane identified. I think that is really an issue for the parties and the institution or the appointing authority to be responsible for. So, you know, I will confess that having pored over the rules to see if I can identify a set of rules that are best suited for investor-state arbitration, I have struggled to do so. As Meg knows, I love the ICSID rules. I think they're great for investor-state cases, but I think at the end of the day, virtually all of the regimes covered in our book can probably be used for investor-state arbitration. And in the conclusion that brings me to is that the best arbitral regimes, the best arbitral rules are flexible. They fill lacunae, as Arif said, but they also leave lacunae open to be filled by the arbitrators and the parties, and sometimes by the institutions. And I'm, you know, as Jane was speaking, I looked at a few rules, a few sets of rules about how the tribunal should conduct the tribunal, the arbitration. And just to give a few examples, the AAA says, AAA ICDR, quote, the arbitral tribunal may conduct the arbitration in whatever matter it considers appropriate. The CTAC rules, the arbitral tribunal shall examine the case in any way it deems appropriate, unless otherwise agreed by the parties. The Hong Kong International Arbitration Center, subject to these rules, the arbitral tribunal shall adopt suitable procedures for the conduct of the arbitration in order to avoid unnecessary delay or expense, having regard to the complexity of the issues, the amount in dispute, the effective use of technology, and provided that such procedures ensure equal treatment of the parties and afford the parties a reasonable opportunity to present their case. So the rules, at least as drafted, provide considerable leeway to the panel and the parties to construct an arbitral procedure that they feel best suits their particular case. And to the extent that there are cultural differences, to the extent that there are flaws and faults, I would suggest that the fault lies not in the rules, but perhaps in ourselves. And that we can take the rules as they have been written and mold them to address many of the problems that we have been discussing.
Thank you. I'm wondering, when you talk about the difference in regimes for ISDS and commercial arbitration, two specific factors that are typical of an ICSID arbitration and aren't found elsewhere are the availability of annulment and the simplified recognition and enforcement. Are those relevant differences? As you were saying, all rules could probably be used, but
Yeah.
are those two things a difference?
They are. And I will confess then when we are representing claimants in investor-state arbitration, and where the treaty provides for a choice, say between ICSID or UNCITRAL or Stockholm Chamber or whatever, we will often think about where we would want to seek enforcement. And the fact that the New York Convention has a public policy defense, whereas the ICSID convention does not, is often a relevant criteria. So there are key there's no question that there are key differences. That we think about those differences when deciding, when we are representing the claimant. Obviously, we don't have as much latitude to do that when we're representing the respondent, although I think it's worthwhile for states to think about the fora that they include in their treaties. But at the end of the day, I think those are differences that may go more to the nature of the particular investor-state case than to the distinction between investor-state arbitration and commercial arbitration.
So there's a lot of strategy based on the facts of the individual case and where you think you're going to end up.
Exactly.
Yeah.
Exactly.
Interesting.
Yeah.
Interesting.
Yeah.
Does any of the audience have questions? All right, and we're going to pass to Ryan, who's going to talk a little bit about, in particular, expedited arbitration, which is something that ICSID has started to propose in its new rules. So we're very interested to hear your thoughts on this.
Okay, thanks, Meg. Let's put the Please open your books to Chapter 10, Section 1, and let's look at expedited proceedings. There is a PowerPoint up on the screen to help us kind of work through. We're going to look at the design of expedited procedures and think about the current proposal to amend ICSID's rules in this regard. Expedited proceedings are special fast-track procedures especially designed to achieve a fast and inexpensive outcome, particularly for cases where the amount in controversy is relatively low. The idea would be to keep the time and costs in proportion to the amount claimed, right? But there's a challenge here, and it's been noted in a lot of the different literature out there, that when you try to speed things up and cut costs, there's a trade-off. And you have to start to diminish and even dispense with certain aspects of party autonomy, which has to do with the party's ability to have input and a say over how the proceedings are going to go, as well as due process, right? Can't have unlimited rounds of written submissions and a 2-week hearing if you're trying to control time and costs. So something has to give. The rule book takes a comparative analysis of 9 different regimes, 6 of which now offer expedited proceedings. And so we can look at the different approaches taken by these regimes and sort of situate the ICSID proposal in that context as a way of evaluating it. Some key issues, and if I don't get through all of these, at least we'll see some of these. But with respect to party autonomy and setting up the proceedings, you have rules about opting in or opting out of the procedures, the number of arbitrators, 1 or 3, and whether or not to have a procedural conference. And with respect to due process, once the main proceedings are underway, there are rules about how to possibly limit written submissions, maybe even cut the hearing, and whether or not the tribunal must give reasons for its decision, all of which take time. So in the area of party autonomy, let's talk about opt-in or opt-out. So most of the regimes take an opt-out approach. That means the expedited proceedings those rules will apply automatically to any dispute where the amount in controversy falls below a certain threshold, right? And it'll be up to both parties to agree to opt out of those proceedings, right? So it's an automatic application based on a low amount in controversy. The SCC uniquely uses an opt-in approach where those procedures are available, but both parties have to agree to apply those procedures in order for them to take effect, right? You can see that the opt-out approach is a little bit more interested in efficiency because you're automatically going to have more expedited proceedings, where the opt-in approach is giving a nod to party autonomy by letting the parties choose to apply that regime. Now, where does ICSID's proposal fall? Rule 74 in the proposal would create an opt-in regime. Slight preference there, possibly for party autonomy. Now, for those regimes that set an amount in controversy to trigger the application of expedited procedures, there's kind of a wide variation. At the Hong Kong International Arbitration Center, every arbitration where the aggregate amount of claims falls below 3 million, about 3 million US, have automatic expedited procedures. At the other end of the spectrum, Singapore International Arbitration Center sets the threshold much lower, and it's going to capture many fewer cases as a matter of automatic expedited proceedings. So even here, where SEAC is using the opt-out method, by setting the threshold really low, they're leaving a lot of cases up to party autonomy for expedited procedures. All right. So that's another way of going about it. And another issue to consider is sort of a escape hatch rule, which would allow the institution or the tribunal to convert the expedited procedures, even though it's a low value claim, to ordinary proceedings because of the complexity of the case, right? Value is simply a proxy for complexity, but there could be a case where the value is really low and yet the factual and legal issues are quite complex. And several regimes offer that sort of escape hatch. So in the case of ICSID's proposal, instead of doing opt-in, they could use opt-out, set a low dollar amount, and include a rule like this. And that would still give a nod to party autonomy, but you'd probably have a lot more cases to which the procedures apply because it's automatic. Something to think about. With respect to number of arbitrators, the AAA ICDR rules and the Stockholm rules mandate absolutely one arbitrator. Of course, that'll be more efficient. It'll be faster. So on the other end of the spectrum, some of these other regimes have a default rule of one arbitrator, but will permit the parties to agree to 3. And that'll slow things down. So this is a little bit of a nod to due process and party autonomy. ICSID, once again, erring on the side of party autonomy, will allow the parties to choose 3 arbitrators, even in expedited proceedings. Procedural conference. This is where the parties and the arbitrator come together to decide a lot of the ground rules for the procedural calendar and other issues that aren't prescribed by the rules. Certain regimes, interesting, all of these are in the East, would dispense with the procedural conference. It's much less democratic and on with the show according to the arbitrator's discretion. Whereas the ICDR, SCC, and ICC preserve the procedural conference even in the expedited procedures. So where do you think ICSID comes out? Once again, they're going to keep the procedural conference in place. Now let's go to due process. When I say due process, I'm really speaking about the right to present your case, right? AAA, ICDR, and CTAC, again, seem to want to really move things along, and they're only going to permit 1 round of written submissions. At the other end of the spectrum, Hong Kong and Stockholm would permit 2 rounds, if appropriate, which tend to take more time, but that's more due process. ICSID proposal guarantees 2 rounds of submissions in Rule 80. uniquely, and I think this is a welcome change, no other regime has attempted to put in place any page limits in international arbitration. And so this is where ICSID is going to guarantee the 2 rounds of written submissions, but limit the page number and the amount of time that the parties have to prepare them. Query whether those limitations impinge too much on the party's right to present their case. You could imagine if the time frames were cut to 5 days. Jane, I think you had a case that you worked on where that was the case. That might really cause you not to be able to present your case. So this is just a different approach. Hearing. And this might go to what Jane was talking about with cultural perceptions of fairness. But all of the regimes that offer expedited procedures that we looked at in the rule book would allow the tribunal to nix the hearing altogether and do paper-only arbitration to move things along, right? Actually, the hearing is probably one of the most expensive, time-consuming aspects of an international arbitration. So by dispensing with it, or possibly dispensing with it, really expedite things. ICSID, however, alone guarantees a hearing and simply shortens the time frame within that the parties have to prepare it, right? Once again, opting for the erring on the side of caution with due process. Lastly, and there are many other aspects of expedited procedures, but we'll look at reasoned award. The SCC uniquely would leave it to the tribunal to possibly dispense with giving reasons for its decision. And that would save time and money in preparing the award, since it would potentially just be the tribunal's decision on the merits without explanation. The other regimes continue to require, even in expedited proceedings, the tribunal to give reasons. And interestingly, the ICDR once again kind of comes in first place in the race by the shortest time for the tribunal to prepare the award at 30 days. Hong Kong and Singapore rules would call for summary reasons as a way of expediting things. ICSID doesn't provide a special rule on this in the expedited procedures. It just goes to the ordinary rule, which is number 58, 120 days for the tribunal to prepare the award. Query whether, maybe that's too long, it could maybe be cut. But once again, just erring on the side of caution with respect to due process. And what we're seeing in this trend might be reflective of what Alex was talking about, that there are special considerations in investor-state arbitration where the approach does have to be more cautious. And even in an expedited procedure, certain things just can't be given up, right? Now, ICSID does try to save some time by cutting possibly extraneous procedures like tribunal-appointed experts and site visits. Although these other rules, interestingly or ironically, actually are designed to save time in ordinary proceedings. You could bounce a claim out for manifest lack of legal merit. You could bifurcate the proceedings and decide there's no jurisdiction and it's over and done with. And you can consolidate proceedings to sort of save time across multiple arbitrations. But all of these are dispensed with in ICSID's proposal for expedited procedures. So we come back to the original challenge of how to balance party autonomy or due process on the one hand and efficiency in terms of time and cost on the other. And maybe the process that is due is different in each case, and maybe the process that's due in an investor-state case is higher than in a commercial case. But we see a definite trend in ICSID's proposal vis-a-vis all the other regimes, and yet there are places where perhaps ICSID could take a different approach, or borrow ideas from the other regimes, and tweak their final proposal before it's implemented. So hopefully that's a useful application of the rulebook and helpful to ICSID. And with that, take some questions.
That's great. Ryan, I think you hit one of the things that we kept coming up against when we said expedited procedure is there's something different about investor state, and in particular investor state based on a treaty that means you have to have a little bit more of the due process or some of the things where we were sort of exercising caution. But what it meant for us was, how do you build in incentives to use the expedited system, because there is a systemic benefit, and yet not take away, as you say, the sort of due process requirements that the parties have. And this is going to be one of the interesting things once this gets out there, to see what kind of cases it's used for. And I can say certainly my expectation is it's much more likely to be used in the contract type case, the investment contract, as opposed to the treaty case, just by the nature of the issues. I don't know what your expectation would be, but I'm wondering, what would your expectation be, and how would you build in incentives to get parties to opt into this kind of a process?
I think it could be interesting to go a step further, and rather than simply looking at other regimes and picking and choosing interesting approaches, maybe a completely different approach would be to kind of reverse engineer the whole thing and establish almost like a graph of what parties are willing to spend on costs and legal fees in proportion to the amount in controversy. If you could kind of come up with that number, like for smaller claims, $1 million dispute, I'm willing to put in $100,000 in costs and fees, right? And then try to design a procedure that can be done for $1 million. And it might even be, or for 100,000, sorry. And it might even be interesting, rather than prescribing all of this, as the other regimes do, to provide a menu. Is this, now we're getting a little academic, but what if there were a menu and the parties, in the interest of party autonomy, could say, well, we'll do with one arbitrator and save a little here, but we really want a procedural conference so that we can have some input on the details. And I mean, what if there were dollar amounts assigned to the costs associated with these different niceties or luxuries of party autonomy and due process? But you could kind of tally it up and go, okay, here's my $100,000 procedure. But anyway, I think short of all that, if there were reason to believe that the expedited procedure really could get the job done in under a year for a certain amount, that would entice people to use it, I think. But I don't know, just some thoughts about that.
Martina.
I'd be interested to hear if you know of any investor state expedited arbitrations under the rules that you just mentioned.
I don't. I mean,
they would have to be under a certain.
Right. It could be under the Stockholm rules, I suppose, but or SIAC actually. But all of these procedures are relatively recent vintage, so there won't be, even if there have been a case, it might not be a lot there.
I can add experience of not an investor state case. It was a commercial arbitration. One party from Australia, one party from the US. So automatically it was going to be a difficult case to manage, not least arranging phone calls when everyone was awake. And it was a very complicated question about ownership of intellectual property rights in a device that keeps nuclear power plants from taking off when you turn them on. It holds it to the ground. So there were engineering issues that had to be dealt with. And there was a contractual 6-month requirement from start to finish of the arbitration. It was ICC. So first of all, I had to do battle with the Secretariat at the ICC and say, no, really, 6 months, it's what the contract says. Everybody agreed we had to stick to it for various reasons. And we had the most amazing chair of our 3-member tribunal who designed a procedure that was so tight that nobody had room to breathe, but there was just time to get everything done. We had a phase of discovery. We exchanged briefs on fact and law on a Friday in December. I remember the day very well. The following Monday, we started and had a 5-day evidentiary hearing. Finished on Friday at about 1 o'clock. We had to submit post-hearing briefs by close of day on Wednesday. That was the best brief I've ever written, because it was so fresh in my mind that I could see all the connections without having to go. I was only going back to the transcripts to fill in the page numbers. It was all in my mind. So we did it, and we got the award. The award was a bit slow because there was a dissent, but we got there in 7 months from filing of the request for arbitration to getting the award. What we didn't have in that period was sleep, obviously. But it can be, the point is, it can be done. It just takes some kind of pressure on the parties to get on with it. And the question, I think, is where does that pressure come from? Here it was from a contractual provision.
But I think you bring up a really good point, which is the resourcing, and that's not just the arbitrators. You're going to have to find an arbitrator who's willing to meet all those time limits and to make sure the process keeps on ticking on that track, but also counsel, I think, because you can't be doing 15 other things if you have to meet those short time frames. So it requires some resourcing and some thoughtfulness about how you're going to staff a case.
Absolutely right. And critical was the chair of our tribunal, who was amazing. I knocked on the door of the tribunal's breakout room at one point, and the chair came and opened the door, and he had in his hand what was very clearly the draft award that he was filling in at lunch breaks and in the evening as we went through the hearing. It was the amount of work the tribunal put in was truly amazing. So it can be done. And that was with no special rules on expedited arbitration. The chair designed that procedure with our input.
It's fantastic. Other questions? Martina, did you want to?
Well, I just wanted to add, one of the reasons that we have an opt-in in the current draft rules is that we sort of recognize that, you can have contractual arbitration, you can have treaty arbitrations, and even with low amount in dispute, for instance, the Abaclat case, would have been very difficult to do on an expedited basis. I mean, the legal issues involved in treaty cases can be very complex, and you don't have that privity between the state and the investor, meaning you first need to get the state on board with its counsel. And we recognize that the expedited arbitrations do not fit all cases. And it would have been very difficult to states to just have an opt-out mechanism for any kind of cases, even if they were below a certain amount. But we're still exploring that, though.
Yeah.
As I was listening to Ryan, I was trying to think of investor state cases that might be suitable to expedited proceedings, and I can't think of a lot, but I jotted down Malaysian salvors, right? I mean, if I remember correctly, it was a few $1 million. It was about a contract to, search for sunken treasure off the coast of Malaysia. It was a pretty simple case handled by a sole arbitrator, although I think it ended up getting annulled, right? But
Exactly. And on the legal issue, or a lot of discussion on the legal issue of what is an investment.
Yeah,
So
right,
even in something
right.
that should be relatively straightforward,
Yeah, no.
you've got these legal concepts that can make it really tough. Yeah. No, it's true.
What about the standard ex-pro case? I'm thinking of Santa Elena, where there's not really a dispute that the expropriation happened or that compensation is due. It's just a quantification of damages. And so that's just a really straightforward case. You could have a damages expert, you could do written submissions, and the arbitrator could make the determination. There may be a lot of cases like that.
Yeah,
so.
something like that.
One other concern I had too, though, with the opt-in approach, what if you have a claimant who's not very well financed and a pretty small claim? the respondent state could withhold its consent to do expedited proceedings and thereby sort of force the claimant to be dragged through the full time and cost, which might actually be all out of proportion to the claim, and effectively kind of nullify the rights and remedies that the claimant has under a treaty. So it's just something I thought about. In a particular scenario, you could wind up with a nullification of a claim effectively.
Yeah, one of the things, I mean, we thought about that issue sort of not specifically in the lens of expedited, but that's one of the other so-called innovations, but we are trying to make arbitrators into active case managers. So we've put in sort of case management conferences, and hopefully that plus sort of the duty to, you know, deal with something expeditiously, cost effectively, that's meant to all be part of the package that the arbitrator brings. So hopefully in your situation, that would be something that they actively manage.
Okay.
But it's interesting because in consultations, we had some states and some private sector persons saying, no, that's not really what arbitration is. It shouldn't be case managed. It's the parties' process. It's not, the system is there to serve the parties and not vice versa. So you even get down to that basic philosophy difference.
Okay.
Anyhow, I want to open the floor just to any further questions on any of the topics we've discussed or anything else. Yes, go ahead.
Stan? Yeah. I have a question about something that was raised earlier in the discussion. You mentioned that mediation is a good tool for streamlining the issues in dispute, and you also referred to the fact that the parties are more comfortable to share what is their core interest when they're not in the arbitration win-lose environment. So with that in mind, and with the Singapore Convention coming into play, as counsels, would you expect the parties to shift more towards mediation from arbitration?
At least I don't think so. I think there will be a time lag, simply because the Singapore Convention is just like with anything new. It needs to embed itself into the culture. I mean, I think if I think back 20 years ago, I mean, there was this renaissance of thinking about mediation. Mediation was going to be the panacea for all of the ills of the arbitral process and all the delays, and it didn't really come about. And I think that there were too few mediators. I think that mediation was not. It was more theoretical in terms of what mediators were doing. I think that there will be probably two significant drivers or three significant drivers as to what will lead to mediation coming more into the forefront. The first, I think, is third-party funding, and really we call it third-party funding, but what it is it's time value for money litigation, and the funders want early settlements. Third-party funding is here to stay. It's a reality, and I think will introduce efficiencies, both wanted and unwanted, into the resolution of outcomes, because there's a dollar payoff at the end of the day. So it's not, as we see it today, principled determinations of value outcomes, but rather commercial determinations or financial determinations of value outcomes driven by those who got the dosh. So I think that's one. I think the second is the increasing involvement of participants coming from parts of the world where mediation or non-binding dispute resolution is more accepted. So I think that there will be a greater influence of Asian and Middle Eastern and Sub-Saharan African dispute resolution methodologies and practices that will enter the framework of dispute resolution. And there's a really interesting book by Parag Khanna called The New Asia, which you should read, about the rising Asianness and a pride in being Asian, not just in look but in terms of philosophy, and what that means to change the way in which we look at commercial relationships and what it is that companies from the Far East are now beginning to introduce in terms of the value of long-term relationships as opposed to short-term outcomes. And that, I think, is going to be a very, very powerful influence. And the third, I think, is as arbitrators actually begin to become more comfortable, and I think it'll be a new generation of arbitrators with MedArb. And I think that's something that with more trainings, I would encourage ICSID to actually hold trainings on mediation and MedArb. And I think that mediations are particularly appropriate within the context of investor-state dispute resolution. Why? Because we call it mediation, we call it arbitration, but at the end of the day, if you go back in time, you'll see that how many disputes, state to state or between private parties and states, were resolved through diplomacy and really, sort of shuttle diplomacy. And shuttle diplomacy is really nothing other than a form of mediation. So I think that investor-state disputes could perhaps provide the fodder.
That's tremendous. We've gone a little bit over time, but this has been a fascinating discussion. We really appreciate it. And we'd like to invite you all to join us just down the hall, and you get an opportunity to ask questions one-on-one with each of the authors. So please join us now. And first of all, join me in thanking them very much.